Good afternoon, Council. This is appeal number 19, the people of the state of New York versus Daria Epakchi. Council?
Good afternoon, members of this honorable court. My name is Justin Smiloff, and I'm representing the appellant, people of the state of New York, in this matter. Before I begin, Madam Chief Justice, may I reserve 5 minutes of my time for rebuttal?
Yes, sir, you may.
Thank you. I would like to start with, thank you, Judge. I would like to start with addressing the issue raised by my adversary in his brief regarding the jurisdiction of the court to hear this matter. We submit that the court does have jurisdiction to hear this matter pursuant to CPL 450-92A, which allows the court to determine whether or not the intermediate appellate court's reversal was based upon the law alone or upon the law and such facts which, but for the determination of law, would not have led to reversal or modification. Additionally, in People v. D'Alessandro and People v. Giles, this court found that it's not bound by an intermediate appellate court's characterization of an order and must determine on its own whether a reviewable legal question exists.
Chief, if I may.
Yes, Judge Feynman.
So, more simply, isn't it a fact that regardless of how they label it, when you, as an intermediate appellate court, create a legal standard, just because you call it an interest of justice, you are creating something as a matter of law. And what seems to have gone on here is that this particular appellate term, contrary to every other intermediate appellate court in the state, has chosen to create a rule that allows it to sort of basically do ad hoc justice on each of these, contrary to Nuccio. Would you agree with that?
Yes, Judge, I would agree with that 100%. In the dozens of cases over 30 years, the appellate term has used that rule couched in disguised as an interest of justice determination that is really a legal standard for over 31 years.
Judge DiFiore, may I ask a question?
Yes, Judge Stein.
Yes, counsel, would you just clarify for me whether you are asking us to clarify Nuccio or extend Nuccio to a re-prosecution by a subsequent simplified information as opposed to a long form information? Is that your request here?
Judge, our position is that Nuccio covers both simplified informations as well as long form information. In Nuccio, the accusatory instrument in question happened to be filed on a long form. In that case, there was the misdemeanor and driving while intoxicated, and there was an arrest, and that was the form that happened to be used in that case. However, in this case, the trial judge determined that the fact that the simplified information that was used for re-prosecution here combined with the supporting deposition was the same served the same purpose as the long form. It was the functional equivalent of a long form. So we submit that Nuccio was not limited to long forms, and here the accusatory instrument that re-prosecution was predicated based upon was equivalent to a long form in content, purpose.
Would it make a difference if the second simplified information was not accompanied by the supporting deposition?
Yes, Judge. In that case, you would have just an accusatory instrument, and it would just be the accusatory instrument wouldn't have the narrative section. It wouldn't have the rest of it, whereas a long form has a narrative and a supporting deposition has a narrative that lets the individual know what they're charged with in greater detail so they can better prepare for trial. And here that was provided with the fact that the supporting deposition accompanied the allegation, the accusatory instrument itself, which merely states the charge, the person's name, and the vehicle
So
information.
just to be perfectly clear, if here a new prosecution was commenced with a simplified information without the supporting deposition, giving the defendant the opportunity to again request the supporting deposition within the time limits required, that would not that would have been dismissible right at the beginning.
Correct, Judge. It would have been dismissible upon motion at the beginning.
Okay. Even if the time set forth in the statute generally for providing supporting deposition hadn't run yet on that new prosecution.
Yes, Judge, I would agree with that.
Okay.
But obviously, that's not the situation before the court here.
Judge, can I ask a question?
Yes, Judge Fahey.
Judge Stein's point, I was concerned about that too. You're saying that if the people try to re-prosecute within the allowable time, that there will be another dismissal in the interest of justice? Mr. Smiloff, do you understand what I'm saying?
Judge, could you please clarify the question? I just want to make
Sure,
sure I understand
no
exactly
problem.
what you're asking me.
So it's initially dismissed. You don't have an affidavit in the interest from the officer. And so it's dismissed in the interest of justice. You file a simplified form within the allowable time. Would it still be dismissed? Is that the practice in the appellate term, to still dismiss it in the interest of justice?
Yes, the appellate term, whenever one is dismissed, in every case that they've decided, they will dismiss the subsequent the instrument that was the reprosecution was based upon.
So did that happen here?
No. Here, there was the supporting deposition was provided with the instrument that reprosecution was predicated upon. They actually were served at the same time upon the respondent.
Thank you.
Chief, if I might, I wanted to go back to the question that Judge Feynman was asking. Mr. Smiloff, my understanding is that the court has the power to dismiss the indictment and prevent reprosecution out in the interest of justice, at least if it does that on a case-by-case basis. With me so far?
Yes, Judge.
So if it said there's something, Ms. Epakchi is 17 years old and she's been through a lot and we're dismissing it, you would have no quarrel with that?
Yes, Judge, and we would never have appealed that issue to this court. Right. So it would be a fact-specific dismissal. Here, right. They didn't know.
I got it. That's just where I'm starting from. So next hypothetical, instead of the rule that the appellate term has, they have a rule that says we will always, with no exception, dismiss an indictment when you fail to provide the supporting declaration within the time. That seems to me that's a rule of law. And your position is that's reviewable by us.
Yes, Judge. We submit that is a rule of law, and it's reviewable by the court pursuant to 450-92.
So they have something a little bit different here, which is there's the ability of the people to prove special circumstances to allow the reprosecution. Correct?
Correct, Judge.
So why isn't that still not a rule? That is, it's just explaining essentially that the burden is going to be on the people rather than on Ms. Epakchi to justify the exercise of interest of justice jurisdiction. Why isn't it still discretionary because of that exemption?
It's not discretionary because in each and every case, this rule has been applied. Approximately a dozen cases on this issue have come up subsequent to this case as well. And in each and every case, they've applied that rule, and never in their decision have they specified what special circumstances are. They've never defined it. We submit an illusory term, that they've never provided a definition for. And in the one case, they found a special circumstances were present, People versus Alexander, they didn't say what those special circumstances were. It was a very brief opinion just saying they found special circumstances, not what they are or what they were in that case. And in that case, they were permitting reprosecution based upon
May I
that.
ask a question?
Judge Stein.
Would you agree with me as I look at it a little bit? It sort of seems like the reverse side of the statute, which allows that discretion to dismiss. But basically, what it says is it's an abuse of discretion as a matter of law not to dismiss a second simplified information under these circumstances. Is that how you understand the appellate terms rule?
I understand the appellate terms rule to be that any case they will dismiss on that's reprosecuted unless their arbitrary standard that's undefined can be met, which on the trial level, that's impossible to know because they've provided absolutely no guidance as to what that standard means. So a trial judge is looking at this with nothing to go by.
Judge, if I may ask.
Counsel, is the rule set forth by the appellate term, is that supported anywhere in the CPL?
No, Judge, it's not submitted, it's supported anywhere in the CPL or in Nuccio or any other decision of the Court of Appeals.
Judge, if I may ask a question.
Judge Rivera?
Thank you. And I'll ask this of Mr. Day also. Smello, what's the genesis of the rule? What is the problem the appellate term is trying to address with the quote unquote rule, with this approach?
It appears, Judge, that their primary concern is judicial economy calendar control. And interestingly, once a case has already been tried and it's up to appeal, then it's already taken up a spot on the calendar. So it's a bit of a dichotomy. They cite this in every one of these decisions for calendar control, but it already was tried, it was already appealed, it was already argued before them. So that doesn't even serve that purpose that they cite.
So it's an intent to incentivize compliance so that there's not another document, let's just put it that way, presented to the court?
Correct. It looks as if that they're saying, look, if you reprosecute, the trial court allows you to reprosecute, they appeal it, we're just going to dismiss it. We're just going to reverse the conviction and dismiss it. So why are you wasting your time reprosecuting if we're going to dismiss it anyway on appeal?
Well, Chief, if I may,
Yes.
isn't there also a concern, though, following up on Judge Rivera's question, that these are traffic infractions. Traffic infractions are not subject to speedy trial. And what they're really trying to do is say, you know what, we're not going to let these hang over people's heads indefinitely. This is the only way we can regulate this because there is no speedy trial requirement on traffic infraction.
Judge,
Is that also an alternative rationale?
Well, Judge, although there is no speedy trial applicable to traffic infractions, there is only a 1-year statute of limitations. So after a year, it cannot be reprosecuted. So the cutoff is 1 year anyway. So the defendant will not have the matter hanging over their head for a period of time longer than a year.
Thank you, counsel.
Can I ask one question?
Oh, Judge Fay, yes, excuse me.
Just speaking from experience, Mr. Smirnoff, this is one of those points in the judicial system where practicality and legality collide. I think that it may be a very practical solution that the appellate term is come up with. I don't know if it's a legal solution, but as I understand the problem from my Buffalo City court days, what would happen is the first time out, we'd never have an affidavit because they'd want everybody to plead out. And then the people who wouldn't plead out the second time, they do their work and they get their affidavit. But quite often they'd be overwhelmed, and not always, but in a number of instances, they wouldn't have affidavits to solve the problem. Is that what we're confronted with here?
No, Judge, we're not confronted with that situation.
Well, let me ask you this. Is it your experience that in the first time when somebody comes in on a V&T charge, let's say running a stop sign, that there's no affidavit ever from an officer, or sometimes are they there and sometimes not? What's your experience?
Right now, the vast majority of tickets are served, they're electronic tickets, and the Department of Motor Vehicles has the simplified information and the supporting deposition. It's two separate pieces of paper, and
But it's all done at, let me just ask this, it's all done at once now, isn't it?
Correct. They're both
Right.
served at the traffic stop.
But it didn't used to be that way. They used to be separate.
Right.
Correct. When
Yeah.
the police officer would write the ticket.
So you see what I'm saying about the law and practicality colliding with each other right here. Okay, I've got it. Thank you, Mr. Snow.
And thank you, counsel. Counsel? Unmute yourself, sir. Thank you.
Thank you, Judge. Chief Judge. May it please the court, this is David Davis, respondent. In essence, what the people here are trying to do is circumvent.
Counsel, may I interrupt for a second? I don't know about my colleagues, but I'm having difficulty hearing you. Perhaps you can get closer to the microphone.
Yes, Judge.
Let's try that.
In essence, what the people here are trying to do is circumvent CPL 100.25 and 100.40 by refiling the same simplified traffic information.
Mr. Day, I can't hear you. Turn up the volume on your, that might help. Okay, thanks.
Is this okay?
Sounds
Judge-
fine.
Judge Fahey?
Yes.
So here, what the people are trying to do is circumvent the statute. The statute's being 100.25 and 100.40 by filing a new identical simplified traffic information or uniform traffic ticket in common parlance.
If I may, is it truly identical if they were also serving it with the supporting deposition? That makes it all non-hearsay and gives the details.
It is identical, Judge, in my opinion, because the supporting deposition is not part of the accusatory instrument. What gives the court jurisdiction is the filing of the uniform traffic ticket. And if the uniform traffic ticket is found insufficient on its face due to the failure of the police officer to serve timely a supporting deposition, that divests the court of jurisdiction. And that should be the end of the line.
Judge, may I ask a question, Chief Judge?
Judge Garcia?
Counsel, could you give me as succinctly as possible the principal basis for distinguishing Nuccio?
The last four words of the Nuccio decision, Judge Garcia, and the last four words of the Nuccio decision says, absent some statutory bar. Here, there is a statutory bar, and it's 100.40, which very clearly states that the failure for the officer to timely respond renders the simplified information insufficient on its face.
May I follow up, Judge?
Judge Stein?
Well, wasn't that same statute in place when Nuccio was decided?
Yes, yes, Judge.
Okay, so that doesn't answer how then we distinguish Nuccio, and then I'd add to that the fact that the CPL seems to distinguish between indictments and informations.
So,
And if I may just add to that, Chief, isn't that actually a distinction that we drew upon in our recent case, People v. Hardy, where we said they have to do exactly what they've been doing here. You dismiss the accusatory instrument, and the people have, within certain time constraints, the right to refile. I mean, I don't see the distinction.
So Nuccio is a different case because in that case, the court permitted the case to proceed on a long form information. And a long form information must state reasonable cause, sufficient detail, and set forth all the elements of the crime or the traffic infraction, which in this case, combining the supporting deposition, even if you were with a ticket, it does not. Also, what's interesting in this case is that the special requirements rule is actually not relevant to the case at hand. And in fact, it inures to the benefit of the prosecutor. It gives the prosecutor basically a second bite of the apple by showing a reason why they should recommence the action.
But let me, if I may, Chief, what I don't understand is at the trial level, all right, if you want to get something dismissed in the interest of justice, you have to make your motion as the defendant, and you have to go through that 10-factor analysis. There's 10 specific factors that are enumerated in the statute. Where are they coming up with this rule that they've invented? And how are they grounding it in the CPL or common law?
So, Judge, are you referring to the special requirements rule?
Well, their whole rule about special requirements and special circumstances and whatever that means, it's not defined anywhere. Part of my concern, frankly, about special circumstances is, okay, well, so you got the defendant here driving her Mercedes through 17 years old at a reckless speed through a stop sign, not even coming to a rolling stop. She doesn't have to worry because they're going to dismiss it. And some other, Joe Schmo comes along driving, I don't know, they don't like the way he appears. It's just so vague and undefined. It's very troubling to me.
So, Judge, the special circumstances was actually promulgated by the court in People versus Aucello, which is an appellate term case.
It's one of their early cases doing this.
It's a year before Nuccio. And what's interesting is Nuccio does not reference or mention it. And what's further interesting to me, Judge, is that Aucello was cited 35 times, 33 times of which were after Nuccio, and not just cited by the appellate term of the 9th and 10th judicial districts. It's been cited through many different courts throughout the state. So it's not an issue that's limited to the judicial districts that the case before us was litigated at.
Judge, may I ask a question?
Yes, Judge Stein.
If we could just sort of move on to the rule itself, I looked at a number of cases in which the rule was invoked by the appellate term, and I haven't found anything that defines or explains what the standards are or what circumstances are considered to be special. Can you explain to me what the rule means?
So that's why I raised the argument, my point one, which was regarding the interest of justice, that the court has the power on a case-by-case basis to review the facts of the case. And I recognize that the issue is a mixed one of law and fact. But I thought it was important to point out that the lower court and all intermediate court and so on should have the authority constitutionally to look at the facts of the case by case. The same question was presented to me by Judge Gargiulo at the appellate term. And I said, well, simply, if the special circumstance would be if the police officer is not available, if he's in the military, if there was some aggravating circumstance here. And Judge Gargiulo nodded his head in agreement. So
Can I ask a question, Judge?
Judge Fahey.
Yeah, Mr. Day, I think what concerns me is not the exercise of interest of justice jurisdiction in an individual case based on individual facts. That seems to be pretty clearly within the power of the court. What I wonder, though, is in this situation, it seems that the exercise of interest of justice jurisdiction has been converted to a legal precedent that may be contrary to precedent in other parts of the state. And that's when it's not interest of justice jurisdiction. That's when you're moving to legal precedent in circumstances and establishing legal precedent that's contrary to the law in the rest of the state.
Judge Fahey, my response to that is that there's not a single case in this state where a subsequently filed uniform traffic ticket was permitted to proceed after the original one was dismissed under these circumstances. There's not a single, and I've read 100 of these. This case has been going on since 2013. I've read maybe 100 of these cases to the point where it's hard for me to distinguish the names at this point between the cases. All routinely state.
If I may.
Judge Feynman?
So I just want to understand what you're saying when you're talking about the interest of justice jurisdiction of an intermediate appellate court. You know, we've already talked about the 10-factor test that you have to do at the trial level to get something dismissed in the interest of justice. But are you saying, because I don't think you meant to say this, but perhaps you did, that an intermediate appellate court can look at the record, let's say after trial, completely satisfied that there's sufficient evidence to support the charges, that it's not against the weight of the evidence, but they can turn around and dismiss I don't know, a pettit larceny, a drug case. I don't even want to get into the felonies because of the distinction between felonies and misdemeanors. But you're not arguing that, because that would have absolutely no support in the CPL.
No, Judge. I'm
So
not.
where does the support come then to be able to do that here?
So the support for that would be that it's a matter of discretion. And we would look to this court's own decisions in People versus Baker and People versus Belge, which I cited in my brief, and also the statute in question, which is CPL 450-90, that the court has the inherent discretion to look at the facts of the case and substitute its own judgment for that of the trial court. So that's all I was saying, Judge.
Judge Rivera?
Yeah. Okay. So, Mr. Day, let me just appreciate, if I can fully appreciate what you just said. So, if the court does not rule in your favor on this, does that mean that the appellate term, the day after the court renders its decision, just say, okay, it's not a blanket rule, doesn't apply in every case. We're going to look at the facts, but essentially, statistically, end up in the same place?
So what?
To decide in every case, oh, given the facts of this case, I'm dismissing.
Okay, so if the court were not to agree with me, the only result that I would see is that a simplified traffic information can be refiled, just using a different summons number, and be permitted to proceed even though it violates 100.40 and 100.25, which required the supporting deposition to be supplied in the
Okay, so
first
I'm sorry, I'm not being clear. So then it's your position that a judge couldn't, under the circumstances, say, and I know you filed again, I know the court says that the appellate terms rule is no longer valid, we can't follow that rule, but given the facts of this case, I'm going to dismiss. A court could not do that?
A court can do it in the interest of justice, yes.
Okay.
But
So that's what I'm saying. If the court were to find that this is a rule, that the rule is not supported by the CPL, maybe it's in violation of the CPL, whatever the court might decide, could you get to the same place statistically, that is in terms of how many are dismissed, by just in each case saying it, I'm doing it on the basis of the facts of this case?
theoretically, I believe that the intermediate court could just substitute its own discretion.
Okay, let me ask you a different question, which is the one that I asked Mr. Smiloff, and I said I'd ask you. So what is your understanding of the reason for this approach?
Okay.
What animates the appellate term's decision to proceed in this way? Is it the violation of the CPL, the timeline?
Judge, just to clarify, are you asking me what I believe the
Why do they choose to proceed this way? Why? What problem are they trying to address?
in terms of demanding that a supporting deposition be filed within 30 days, or
No. They'll dismiss if they file a second one.
they're trying to streamline the system, Judge. And to curb overzealous prosecutors. As a litigator, doing this for over 20 years, I don't envy my colleagues who regularly practice at the traffic and violations parking agency, because there are 100 cases on the docket. And it seems as if that the judge, whichever judge you're assigned to that day, doesn't necessarily want to follow precedent. So, in other words, it's important to give the public confidence that their system is working, to give them an opportunity to prepare for their case. And to instill confidence that they're going to be treated fairly.
But if I may.
A final question, Judge Feinman?
Why isn't the solution to that? Go to the legislature and either say, traffic infractions need a speedy trial deadline, or traffic infractions have to be prosecuted in a particular way, whether it's not through a bureau or a district court. Why is it up to the appellate term to create a solution to a problem that it perceives, as opposed to, going to the legislature?
That's a valid point, Judge. I don't see why the legislature would not want to, adopt such a position and look at the issue, but that's not the case we have here. The case here is a very simple one, where a simplified traffic information, which was previously dismissed, was replaced with a new one, which is, there's a statutory bar to it. It's what the legislature did in 100.40.
Thank you, counsel. Thank you. We have your point. Counsel, your rebuttal?
Thank you, Judge. Just very, very briefly. No other appellate courts no appellate courts in the state followed the Acello decision, and all other courts who have decided this issue that I've seen have followed this court's decision in Nuccio from all over the state. There's a decision in Rochester, there's a decision in Osage, there's a decision in Chattanooga County, decision in Nassau County, and I cited them on page 12 of my brief. And I just want to close with this court, after Nuccio, decided a case, People versus Jackson, and found that the teaching of cases like Nuccio is that courts should be wary of imposing the harsh remedy of dismissal in the absence of explicit statutory direction. So.
Thank you, counsel.
Thank you.
Thank you.